local cabinet. The new labour law does not actually set out any penalties for any acts of discrimination, and I'm sure these will be coming along later. So what do you actually need to do? So this is a great time for you to create, if you do not already have, a code of business conduct and include this in a statement on all discrimination areas in your handbook and in your onboarding presentations. So start actually taking the wording from labour law, but also it's equally available out on the internet, because these are things that are very common in Europe and very common in the US. Make sure you include a non-discrimination statement in your recruitment policy and process. And my recommendation is make sure you start doing what we used to do in Europe, keep notes on all applicants that you have interviewed, to show why you decided not to offer that person a role. You don't need to do it for all the CVs because, I mean, let's face it, we're all getting hundreds and thousands of CVs, but you do need to do it with the ones that are shortlisted, just in case someone comes back and questions you, you've got that information to hand. You'll see I mentioned this a lot, an employee addendum. So this is a change of terms and conditions of employment. If it's new that you're introducing company codes of business conduct, make sure you make reference to it in the addendum, perhaps attach a copy of the business code of conduct. And if you are actually updating this in the handbook, then I would make sure that everybody gets given an updated handbook and they sign to say they've had it. This is also a great opportunity for you to do some other enhancements to your policies. So we're all dealing with COVID, what to do when someone's on sick on COVID or someone contracts COVID in the office. What do you do? What are the policies and procedures? I would now put that side of thing in your health and safety policy, make reference to a pandemic related disease, and also include it into your holiday policy, a statement that just says you now travel at your own risk. If you're trapped outside of country, you will move on to unpaid leave, so that you're already making people aware of your new policies. So moving on to Article 6, recruitment and employment of workers. No work can be performed in the UAE unless they're on a work permit. Now, this has always been the law. It is now stated in labour law. So where you may have brought somebody in on a visit visa or the visa on their last employer because you're in process of changing them, it is now illegal to actually do that, and it's stated in labour law. And also you can no longer, well, you never could, but now no longer state it, that you cannot charge a worker or collect from them the recruitment costs or visa costs once they leave you. So if you've got a statement in your offer letter that says if you leave in the first 2 years, we will deduct the cost of your visa, you need to remove that. Now that's all, these 2 points have always actually been the law, but now it's stated in labour law, so it's even more important than now referring to it. So what actions do you need to take? So ensure that everybody that starts work with you commences with a work permit. The visa process is speeded up quite a lot, so this is actually possible for you to do. So make sure this does happen. Include this point in your recruitment policy, so that you are very clear that no one can start without a work permit in your hand. Remove any mention of deduction of visa fees on early termination from your offer letter or terms and conditions of employment, and ensure that you include in a statement in the offer letter the conditions of employment that shows that they only commence once a work permit has been obtained. Models of work. There have now been stated in labour law all the models of work that we are used to in other parts of the world but have not been introduced here. So the kind of key things that we're talking about is freelancers, condensed working week, shared job models and self-employment. Just to explain what is a condensed working week, this is where you can perhaps give the employee a contracted amount of hours, for example, 40, and let them work out when they're actually going to work those hours. So they can perhaps do the working 3 days instead of 5, so they work longer days on those 3 days. And as long as that's understood, they understood what they have to do in those 40 hours, and it's signed by both of you, this is now possible. Shared job model, we call this job sharing in the UK, and that's where 2 people are doing the same job and it's split across 2 different employees. Freelancers, a lot of companies have started doing this, where they are actually taking on freelancers to do a specific job, even if this is a long-term job for a couple of years. It saves them the cost of gratuity, paid holiday, medical insurance. As long as they're on their own freelancer visa, then you create a freelance contract. Part-time workers, it's now possible for employees to work for more than one employer for a number of hours or days, and they're entitled to pro rata annual leave. You'll mention there, I haven't answered anything about gratuity. I'll talk about that in the next slide, but it's one of those unanswered things that we do not know. The new law enables employers to hire workers with expired contracts but are still in country, which is amazing because there are a lot of employees out there that are trapped. They cannot start work because their previous employer has gone bust or they have left the country and they can't get the signature. And it's actually a very complicated system to do currently. And we're guaranteed here, because it says so in labour law, that it should be simple and flexible going forward. All of these things they've been brought in to help you, the employer, harness different talents and competencies to low operating costs, and it helps you to do more business because you don't always need a full-time employee, and now you don't have to because there are visas around this. But we still have quite a lot of unanswered questions. Here's some of them. Who's going to hold the main visa? We don't know. Does that mean we're going to get multiple visas? Who's the main employer and who pays gratuity? We're waiting on executive regulations on this, and I think the labour law change came to a surprise to many of the ministries and the free zone parties. So they're all having to scrabble around working out how the practicalities of these things are going to work. So what do you need to do? I think this is more a case of you thinking a little bit more outside of the box. Ask yourself, do you always need a full-time employee for this position? Are you open to someone doing it at the weekends? Are you open to someone doing it in the evenings? Is this a role that's suitable for job share? And just start opening your mind to that. There's nothing else you need to do, and perhaps including the interview process, some questions around how flexible people are, because I think as the world has evolved, people are not necessarily working during the day, they're working evenings, they're working weekends. There's a lot more flexibility, and now we are able to harness those flexibility options. Employment contracts, I saw a lot of questions about this, so I will not go too fast on this. I'll try and go at a good pace. The unlimited contract is being removed and it's being replaced by a limited or fixed term contract, which is 3 years long, and it's renewable for a similar or shorter period upon agreement of the parties. Now, a lot of you will employ people on unlimited contracts, and you're probably thinking, oh my goodness, how does this work? Well, as far as I can see, it's still an unlimited contract, but they've just changed the name of it. Everything else stays exactly the same. So when you're hearing the word limited, think unlimited. And don't panic. Basically, you now have an unlimited visa that lasts 3 years, whereas if you're on the mainland, it's 2 years. So this is extending the amount of years of the contract. It's supposed to allow you more certainty. It certainly simplified the process, as you'll see when we get to gratuity calculation. But I can understand there's a little bit of panic here. How is this going to work? So when a contract, as exactly as it is now, the limited contract does not end and that's it, halas, finish at 3 years. It means you can renew it in exactly the same way an unlimited contract is renewed now. If I could just give the ministry one advice, I would change the name of this contract. It should be just called an employment contract. It will make everybody's life a lot simpler. All contracts do need to convert from an unlimited to a limited contract within 1 year. That means we have until the 1st of February 2023 to convert all those people on unlimited contracts to fixed term contracts so that you comply with the amended terms. And I would also say those of you that employ a limit on limited contracts will also have to do the same, because all the T's and C's within a limited contract, i.e. termination and compensation on early termination, are removed. They're no longer included in labour law. So we have this grace period. But the whole questions around this is, okay, so if I've just got an employee and I've just renewed their unlimited contract in December, you're now telling me I've got to renew it again within the next 12 months. I've just paid out for this one unlimited contract. Do I have to pay again for the new limited contract? We don't know. My advice would be do nothing at the moment. Hold fire. There's no panic. we don't need to do anything right now. Hold off for a couple of months and wait to see what the ministry tells us. My suspicion will be that this will be something that converts on renewal. But I've been in the region long enough to have seen great ideas, and then suddenly we've had to delay it. So I would not do anything at the moment. Wait until you've seen what happens to people that are on an unlimited contract that run out in, say, February, March, April of this year, to see what happens then. What is their limited contract looking like? I would also be just to take the panic away from yourself and also the panic away from employees, that when you are doing the addendum, don't harp on too much about the fact that this is a now limited contract, because in people's mind that means it ends on a set date, and that means I need to find another job. If you are holding somebody and you want them on an unlimited contract, you want them to know this is an ongoing process, then this is all to do with your wording. I would not mention limited or unlimited in your contract. I would just use the word very vaguely. And if anybody needs some suggestions, I've done this a couple of times for clients. And when we are moving, when you're doing the addendum, say exactly the same thing. Make sure everybody is completely aware this is nothing for them to worry about, that you still want to employ them beyond the 3 years. Probationary period, this is another big change. Probationary period currently in labour law states that you do not need to have contractual notice during your probationary period. You may have added it in, but if you haven't and you've got 0 notice on your probationary period from both sides, that needs to change now. From the 2nd of February, you now need to give employees at least 14 days notice that you are terminating them within the probationary period. So what does this mean practically? It means if you've got 6 months probationary period in your contracts, which is the maximum you're allowed to have under old and new labour law, it means if you are giving 14 days notice, you've got to give that 14 days notice at 5.5 months in order for it to not go into contractual notice. I hope that's clear to people. Employees who want to leave during the probationary period, if they're looking to change employer, they need to give you 1 month's notice, and this is written notice that they're moving on. And not only that, their new employer must compensate you for the cost of recruitment or their contract. So if you've paid a recruitment consultant, they're going to have to pay that. If you've paid visa and not a recruitment consultant, they have to pay that. So that's something that's very important for you to understand, that 30 days notice plus you can claim the money back from that old employer. This is a reason why it's very essential that you have people starting with you on a work permit, so they're legally working with you during their probationary period, which allows you to implement these parts of labour law. If the employee is going to leave the UAE, so they've worked with you for 4 months, decided they need to return home, they must give you 14 days notice of that decision to leave the UAE. And not only that, if they exit the country and return with under 3 months from the date of their exit from you, then the new employer, so they come back into the country to find another job, the new employer must pay you again compensation with recruitment or contractual costs. Now, how is this all going to be managed, Claire? How are we going to get this money back? Well, how it's going to be monitored is currently unknown. My only suspicion will be that it's to do with the visas, which is why it's very essential that people join you on a work permit, or this will not work. Now, where an employee leaves the country without providing notice at all, then you are able to subject them to a 1-year ban from obtaining work permit from the date they leave the country. Now, that sounds great. We're back to the old days. However, there's quite a lot of exceptions by the Ministry of Human Resources. So I would only do this if it's something it's very key with you, because this is going to take time from your day. And make sure your PRO, before you threaten it, checks to make sure that it is one of the positions that you're able to do. And the other change here under Article 29 is that paid holiday is now taken and paid in probationary period. So you cannot deduct it when they leave. Now, under old labour law, paid holiday was not allowed during your probationary, so now it is. So if somebody does leave in their probationary period and they have taken holiday and it's under their entitlement, you cannot deduct it. And in fact, you have to pay them their entitlement if they don't take leave at all. So what actions do you need to take? You do need here, this is where your offer letter, your terms and conditions for employment need updating, your employee handbook and onboarding presentations. This is quite a big change. Include in the employee addendum for your current employees, just so that those that are on your probationary period are aware of this change. Make sure you update your holiday policy to show that they can take paid holiday in their probationary period. And if you have an ERP system, this needs updating. But also, let's look at it from the other way. You are now recruiting. It's very important now that you understand that you're not going to get hit with a charge of the recruitment costs of the previous employer. So if you do not currently do it, take references, because let's face it, employees or candidates do not necessarily tell the truth on the CV. They may be working. We want to make sure that they were not working before they joined you, or if they were working, that they passed the 6-month probationary period. Make sure that even then you get your PRO to check with the ministry. That's possible, to make sure there is no that how long their previous visas was, just to make sure that you're not subject to any claims. Non-compete clause. A lot of us tried to have a non-compete clause in our contract. It was never supported by labour law, and it was incredibly difficult to actually implement and put into practice. It is now mentioned in labour law. Although I'd like to just draw your attention to the line that says you've got to have reasonable reasons why the non-compete should be applied. So you couldn't necessarily have it with quite a lot of positions. I would certainly say for sales, that's something you absolutely could do. Labour law is quite comprehensive on this, so I would suggest you reword, just take the wording in labour law and put it into your contracts. And I'd also suggest that when it comes to a non-compete clause, people always understand, they need to know who you mean by competition. So I think it's advisable to make sure that you have a list of competitors that's updated annually, so it's incredibly clear that who is a competitor and which country you're talking about. So as I said, make sure you update your offer letter, terms and conditions of employment, employee handbook, onboarding presentations to show that, and include it in the employment addendum so that they're signing to say they've read and understood exactly what they are able and not able to do. Can I just ask everyone to put themselves on mute, please? Thank you. Obligations on the employer. This is a throwaway comment in labour law. Sorry, someone's on. Can you put them on? Yeah, I'm off mute now. Yeah, thanks. That was better. I could hear myself. This is a throwaway comment in labour law. I've put it in because some of my own clients do not have accommodation allowance. If you do not have accommodation allowance as one of the allowances you split salary by, and you do not provide company accommodation, you need to make sure housing allowance now forms one of the breakdowns. Why? I'm assuming it's to make sure that everybody has an option to pay for their own accommodation, and it's proven by labour law and in their contract. Half the time the housing allowance doesn't cost the cost of rent, but it's clearing it out. So for those companies that do not include housing allowance, then you need to review the salary breakdown of all your clients, your employees, and confirm any changes to each employee. But remember, you cannot decrease total salary and you cannot decrease basic pay. So if any employers out there have salaries at 100% basic pay, firstly, that's not very good because your gratuity accruals are very, very high. You're going to need to start thinking about how you can implement this, and it may mean you might need to do a salary review at this point so you can actually include housing allowance. So working hours, obviously we've seen the changes to working week, and I'm sure a majority of you have moved to Monday to Friday. To comply with this, Friday is no longer stated as the recognised day of rest. It still says there is one day of rest every week, so people cannot work 6 days per week. Just a reminder for the next two, these are current and new labour law. Working hours cannot exceed 8, 9 in some cases if you're in retail or in hospitality, or 48 in a week. There should be 1 hour of rest, which is unpaid, which must be provided, and employees cannot work more than 5 hours without a rest. The next change that's come in, holy month of Ramadan, it no longer mentions that it's being reduced by 2 hours. It says that it will be announced every year, like summertime working, by an executive regulation. My suspicion is, I suspect that we're going to start seeing that the reduction in hours during the holy month of Ramadan are removed as Ramadan moves into more and more into the touristy season. It also states in labour law, if the employee wants to work remotely and the employer allows this, the employer can set the working hours. So it means that you can be very specific that if they want to work from home, then it has to be during the working hours, and it means that they can be on Teams during that time. So actions to take. If you haven't already announced your change of working week, you should do this now, and you should put it in the addendum of contractual changes. Make sure you update the offer letter, terms and conditions of employment, company handbook and onboarding presentations. These things tend to get missed. We probably still have the Sunday mindset. I certainly have. And make sure you update your company website. I know that's nothing to do with HR, but it's something to remember. Overtime, this was something that was covered in some of the questions that came beforehand. It is now defined in labour law that overtime is paid on basic salary only. It was very vague in our previous labour law, but it's very clear now that it's basic salary only. So for those of you that do pay overtime, make sure you update your overtime policy and then you update your ERP system. And remember, this is effective only from February. So if you've got overtime this month, then you're going to need to pay it under your old policy. Article 22 has a statement that says that salaries can now be paid in other currencies upon mutual agreement between the company and employer. So currently we have to pay in AED and into a UAE bank account, and it's opened this up now. But the outstanding question is I'm not sure how this is going to work through WPS. And this obviously WPS only affects the mainland companies. So it's up to you guys. You don't need to do this. Companies consider if you want to or able to pay in different currencies. And if you feel this is an option your employees would appreciate, perhaps some of your senior team members would rather be paid in dollars. If you are going to pay in a foreign currency, think about how you're going to capture the exchange rate. Is it something you're going to capture on a monthly basis? Are you going to capture it on an annual basis? Make sure that you use the Central Bank of the UAE to actually set the figure, and make sure that goes into policy. If this does work for you then, and you want to do it, then I would suggest you go direct to your WPS provider and ask how they're going to work this into the system. And then update your ERP, and then ask your employees to confirm in writing their preferred currency. I'm assuming we still need to pay into a UAE bank account, but it doesn't say you have to in labour law, so perhaps my assumption is incorrect. For those employers out there that do make deductions from salaries, I've put it in one line. It's actually 2 pages of information in labour law, and it's based on the percentage of salary that you can deduct every month. Now, some of you probably give housing loans. That's not subject to this part of labour law, but of course make sure before you hand out that loan that you are first of all making sure that they can pay the money back if they were to leave from their final settlement. So that's always a good check to make sure the money's in their gratuity amounts, but also that you've signed agreement from the employee to say they will agree to this amount of being deducted over this many periods, and it's a repayment of the housing loan. And make sure you also include a statement that says, on my termination, the remaining amount can be deducted from my final settlement. It just covers you on these particular areas. But if you have deductions for turning up late or money lost in the till, refer to labour law, check exactly how much you can, because it is based on a percentage of total salary, and make sure if you have a deduction policy that you update it. If you do deduct and you do not have a deduction policy, write a deduction policy. Minimum wage, yes, another question that was asked. It is now mentioned in labour law, so minimum wage will be coming, but the amount of it and how much and when is it coming in is yet unknown, and it's going to be set by the government. So for you to do nothing at the moment, we need to wait for a government directive. Maternity leave, there have been some changes here. So maternity leave has increased from 45 days to 60 days, 45 days with full wage, 15 days on half wage. There's no mention anymore about a reduction of 50% with service under 12 months. So therefore, all employees, regardless of service length, are entitled to full maternity leave. New mothers are eligible to receive an additional 45 days without pay once they finish their maternity leave in case of any complications, sickness in the newborn. But you need to have documents to prove the sick leave. There's a reduction from 18 months to 6 months for the time taken during the working day to nurse your child. And new mothers, infants with special needs are entitled to an additional 30 days paid leave on completion of their initial maternity leave, renewable for a 30-day period with no pay. And there are new entitlements on the delivery of a child that is sick, with special needs, or in the unfortunate death of a baby after 6 months of pregnancy, or in the death of a child on delivery. In those cases, they're able to take the maternity leave. So actions to take: update your internal policies handbook, onboarding presentation, include the update in the employment contract or addendum to all employees, update your ERP, and don't forget to do this. Who's currently on maternity leave? Will the new law changes on the 2nd of February affect them? If they are still on maternity leave, when that crossover period, it does affect them. So make sure you update them, their payment methods, and also make sure that you tell them that they have an additional 15 days of maternity leave. So the other leave is that the leaves that have been implemented: compassionate leave. Employees are entitled to 5 days compassionate leave on the death of their spouse, 3 days on the death of the parent, child, sibling, grandchild, or grandparent. You may feel some of those dates or those times are not good enough. That's fine, increase them, but you have to have as a minimum 5 days and 3 days as stated there. Study leave: employees with more than 2 years of service are entitled to 10 days study leave per year if they're enrolled in an accredited institute inside the UAE. And parental leave has recently been added. It's 5 working days, but I just thought I'd remind you here. So what you need to do: update your leave policy to make sure all the leave types are in there. If you do have compassionate leave, make sure you check it to make sure it is as a minimum in line with labour law. Include your changes in the contract addendum and update your ERP system. For those of you with disciplinary policies, you need to know that suspension from work is now paid at 50%, and it cannot be longer than 30 days suspension. So what do you need to do? Update your disciplinary policy to effect the change in suspension. And if you do not have a disciplinary policy, introduce one to your handbook. You absolutely need this. It's going to be a godsend in the event that you do need to take action. Cases of ending employment: redundancy is now a consideration, but the law implies that it's on full company closure rather than a specific role. I still believe you can make a specific role redundant, so my suggested actions here is to include a redundancy as a company recognised reason for leaving in your ending employment policy, include it in your handbook and onboarding presentation, and make sure that you follow your policy. Okay, we're nearly there on the slides. This is quite a key thing coming up now. So contractual notice cannot exceed 3 months or 90 days. So anybody out there with senior members on 6 months notice, that needs to change. It's no longer legally allowed. During a contractual termination by the employer, so when you terminate someone, the employee is entitled to 1 day per week without pay to look for a new job. You will probably already allow this. You probably allow them to use their holiday pay, but if they are out of holiday pay, they are able to use 1 day a week unpaid. And remember that 1 day a week unpaid will reduce their gratuity amount because their service lengths will change. So actions to take: for employees with contractual notice over 3 months or 90 days, make sure you change this in the ERP system and also in the contractual change addendum and gain their signed agreement to this. Update your leaving policy to include this information, and also update your ERP system. Dismissal of a worker: it used to be Article 120, it's now Article 44, gross misconduct. The reasons in there are still the same. The main difference here, and I'll say this very, very slowly, Currently, under labour law today, when you terminate someone under Article 120, their gratuity amount is not paid. Under Article 44, from the 2nd of February, termination for one article under Article 44, their gratuity is now paid. Their notice is not, it's still withheld, but they're now entitled to their gratuity amount. So you need to update your company employment policy, updating the handbook and onboarding presentation, and make sure your settlement calculator is updated. I would not advise letting your employees know this change. The next piece of information, again, with severance pay, is it's simplified because we're now on one contract, not on a limited contract and unlimited contract. There's no change to this first line. So gratuity under 1 year, they get nothing. Between 1 and 5 years is 21 days of paid days of service, 30 days thereafter for every year of service. Service length is reduced, as it always was done, but I thought it's best to remember this because quite often this is forgotten. If someone's taken a month's unpaid leave, you can reduce their service length by that 1 month. It's now exactly the same calculation if someone resigns or is terminated. So where we previously only paid 1/3 of the gratuity between 1 and 3 years service and 2/3 between 3 years and 5 years, now it's the full amount. There's no difference between resignation and termination. And here's the biggie. Gratuity basic pay is still paid on basic pay, but it mentions in labour law in both English and Arabic that it's working days calculation, not calendar days. So this is going to increase your accrual on payout. Why? Because currently that 21 days, that 1 day of day rate is calculated with their basic pay times 12 months divided by 365 days. It's now going to be divided by 260 if you're on 5-day-a-week contract, which is potentially a 33% increase of your accrual that you need to accrue, and also the amount that you need to pay out. Now, remembering this is effective from the 2nd of February. So if you've got anybody whose last day of working is the 2nd of February, it is currently stating that final settlement is paid on working days, not calendar days. Now, it's highly likely that we should see an update on this because I think this is a mistake. I've seen something by a law firm to say it definitely is a mistake. It was badly worded. But until we have clarification from the Ministry of Human Resources and Emiratization, I think we have to assume the worst case scenario. I went onto their website yesterday, and although it's telling us the countdown to new UAE law, it still states everything as the old law on the system. So if you do have someone leaving on the 2nd of February, I would wait and see what the website does. As soon as we've heard anything different, we'll also let you know. So the actions you need to take is update your gratuity and final settlement policy and calculate it accordingly, and update your ERP system. Again, this is information I wouldn't necessarily tell the employees, but then I would never have had this calculation of severance in a handbook anyway. It's openly available on the internet for these guys to calculate themselves. Okay. We're nearly there. So payment of workers for their final settlements. It states in labour law that payments must be made within 14 days of the expiry of the contract, i.e. on the termination of the contract. Now, we all know that we actually often allow employees to stay on our visa for a couple of months to help them out, to allow them to get a new job. Now, it says contract, it doesn't say visa in labour law. So it implies that if your date of leaving is today, the 20th of January, then that final settlement has to be paid out 14 days afterwards, which means we would only do that on visa cancellation, which means it's beginning to look like we cannot help employees out if you do in fact do that. So what do you need to do? Make sure that you update your leaving company employment policy, that the final settlement checklist, make sure that this payment is released in line with this new legislation. and then, like I say, it is now removing any help you actually can give employees. So what do you need to do? So you've got until the 2nd of February to put a lot of this work into place. Ensure that all policies and contracts are compliant to updates. This means update to your offer letter. Do that first, because you may be making offers of employment today that people joining are after the 2nd of February. That's the first thing that needs to change. So anyone new joining knows the new rules and regulations. That you update your handbook, and then you update your onboarding presentations. And if you can do all of that before the 2nd of February, then that's fantastic. You need to go through all your current employees. What are their terms and conditions? Are they out of date now with the new legislation? In which case you need to come up with an addendum to the employment terms of contract. And depending on how many staff you have, make that a generic thing. Perhaps get everybody together to get them to do. It's a great time to refresh on what the handbook states, so that people can see exactly the changes. You can record who's attended, so you've got the evidence of the people that attended for the feedback on this. Make sure that all employees and management are aware of the changes. So HR departments, it's not just you that need to know the labour law, it's all the department heads that also need to know the labour law, so they're advised and they can help their employees when they are dealing with them direct. This is an awesome time for you to now refresh your handbook, refresh your policies, provide training on equality, diversity and dignity in the workplace. This is a great step forward in the region, and I think it's time for us to celebrate this. So this is a great time to clear everything up, make sure your policies are in line with the future so that you're able to grow and develop. And once we get clarity on the timelines of the change from unlimited, when we have to do it, you need to move everybody over to the new contract. And you have 12 months currently to do that. That's the end of the presentation. Hopefully, I'm going to stop sharing the screen now. There's my contact details if you need me. So if you want to just take a screenshot of that, or go through to Kazi and he will send you the information. Let me just stop sharing my screen now and see the questions, if there are many in the chat box. There are a lot in the chat box. Okay. So we've got 20 minutes for me to work a miracle here and calculate all of this. Let me try and get to the top. Good morning, good morning, good morning. Hang on, what's the main difference between the old labour law and 2022? Hopefully I've now gone through that, so that's answered your question. Is having a handbook now mandatory? No, it's never been mandatory, but it's HR best practice to have an employee handbook. So if you don't have one, get one. This is even if it's a simple one, because this really allows employees. Sorry, Kazi, can you put everyone on mute again, please? Thank you. Sorry, handbook. Is it mandatory? No. Is it best practice? Yes. If you don't have one, get one. If you don't know how to write one, get someone to write it for you. Would the law be changing in JAFSA? Well, my understanding of JAFSA is it had its own policies and procedures anyway. They were very aligned to mainland UAE. So I suspect they will also update them in line with these changes. So I don't know the answer to that, but I suspect yes. DIFC, they already have their own policies. These changes are not in line with that. And if there is a question, are these labour law changes mainland only? No, they are free zone, because if you go to Fujairah free zone, DMCC, their laws are exactly the same as mainland, so they will be affecting them as well. If an employee is not allowed to work for more than 8 hours in a day, the example of a compressed working weeks? Because this is where 48 hours a week is the sort of fallback. It's in agreement with the employee. So if the employee says, I want to work a compressed working week, as long as you've got that in writing, that they're signing off that they're going to probably work, well, they'll have to work more than 8 hours in a day, and they've signed that, then you have it in writing, as long as they're not working more than 48 hours without financial compensation. Please let us know if we need to make changes to the already limited contract. I don't know the answer to that. I work logically. The limited contract restrictions are no longer mentioned in labour law. It's just one contract only. It's only one set of rules. So therefore, the limited contracts are going to change. They have to. It's logical. So I suggest You check that with your mainland to get your PRO to check it. But I believe I'm 99.999% sure the answer is yes, because limited contract terms and conditions are no longer mentioned in labour law. Will there be a contract termination policy for this year, three-year contract if either party terminates it? Well, there is contractual notice in the labour law, and it's no more than 3 months. And if they don't work the 3 months, they need to compensate you. And if you don't give them 3 months, you need to compensate them. Will the visa also be valid for 3 years? Yes. Yes. The next question was the same question. Having a limited contract does not mean we have to compensate the employee if the contract was terminated before the specific period. The limited contract, the new limited contract can be under 3 years. So if you only need someone for a year, you can set it for 1 year, but the contractual notice is the same. It's still maximum 3 months contractual notice. Is a limited contract now easier to terminate upon expiry than an old unlimited contract? That's a very good question. I think if you wanted to terminate it on its expiry, so you want them no more than 3 years, then you need to state that in the terms and conditions of employment, and so everybody is clear on it. I think with anything to do with HR, it's clarity. As long as you're clear, the employee's clear, they've signed, you know, doing things verbally is where you get yourself into trouble, people. You know, when you have a verbal warning, if you don't follow that up in writing, that's where you get yourself into trouble. Never agree anything verbally, agree it verbally and then follow it up in writing and make sure they sign it. Question on allowance. If a total salary cannot be reduced, does this mean that the allowance are provided cannot be reduced? Can we say a certain allowance are temporary in nature to cover this? It's only basic pay that you cannot reduce. You can reduce an allowance. So, for example, if you do not have a housing allowance, say you have basic pay at 50%, allowances at 50%, you can take that allowances now and cut it up as how you want. If you have basic pay at 80% and the rest at transportation allowance, you can now cut that transportation allowance in half and go 50% housing and 50% transportation. There's no rules on that. The only rule is you cannot reduce a basic pay because basic pay is linked to gratuity. Is annual leave entitled if staff resign during probation? Yes. So leave is accruing from the moment they set foot in your office and start working. So if they're on 22 days working holiday, then they have 11 days for the first 6 months. If they leave at that 6 months, they're paid 11 days. Could you please clarify 144 hours mentioned under Article 19? I'll come back to that just for the speed of going back to see what Article 19 was. Maximum number of hours an employee can take in a day, SPL in the production unit. It's still one, I think you mean days, time off. It's because they're limited to 8 or 9 hours in a day, it's still 1 hour of unpaid leave in a day. Is the partial gratuity permitted in labour law? I think that means, can I release gratuity early? Yes, you can. It's not covered in old or new labour law. If you can afford it and it affects your P&L and you've got the money, you can, but make sure everybody signs up for it. And a word to the wise, make sure it's deducted in the ERP system, so it's recognised everywhere, great big red writing everywhere that you've released part of it, because if you release it at year 5 and then that employee stays for 15 years, someone's got to remember at the 15-year mark that you've already released part of it. And you don't want to release it twice, but you can release it. Part-timer contract less than 1 year will accrue paid vacation. Yes, the part-timer will, but it would be an
please unmute yourself there again.
Okay, sorry. Part-timer contract less than 1 year will accrue paid vacation. Yes, they will, but again, a part-timer's holiday entitlement is prorated based on the amount of days that they're working or hours they're working. So if you're contracting someone for 3 days versus 5, then you would prorate the holiday entitlement down to reflect that it's a 3-day-a-week contract, not a 5-day-a-week contract. So if yes, will the non-used accrued vacation be paid on completion of contract? Yes, of course. With the maternity leave, please advise the breastfeeding mum can go home 1 hour early after their maternity leave. Yes, it used to be 18 months, it's now 6, so they can do that. Is there an official guideline of fixed monthly split between basic and other allowances? I really wish there were, but unfortunately there is not. It really would help everybody, I think, if they actually told you what the basic pay should be. It's purely your own industry regulations. How does basic pay have to be specific percent of total? It doesn't. Retail tends to be very, very low. And then the most I've seen is 100%, purely because the person didn't know that they could reduce it down. They thought it was supposed to be 100%. So it's anywhere between 10 and 100% basic pay. And it's really to do with your industry. You need to make sure that you are attracting the right level of employee to join you. And if your basic pay is under your competitors, they're going to join your competitors. What if the employment has unpaid days? Can we deduct those days from gratuity calculation? Yes, you can. You reduce the service length, and that then affects the gratuity calculation. So that's why you all should always make sure you record exactly how many days unpaid leave somebody takes. On the calculation of gratuity, can we make the calculation based on? Oh, no, that's a good question. Can we say that up until the 1st of February 2022, it's on the old calculation and now it's on the new calculation? No, the labour law is effective and it backdates. So it unfortunately is not allowing this, unless that's what they decide to do to fix the issue with the fact that this is going to increase significantly. At the moment, it's reads, and again, it's not super clear, but the implication is that it's affecting everybody from the get-go. We make the bulk payment within a week of last day to keep on hold someone amount to hold on to someone until the visa cancellation. We make the bulk payment within a week of last day and keep on hold some amount. That's up to you. That's your own internal process at the moment. All I'm saying is labour law is very clear now that it 100% needs to be released within 14 days of date of leaving. So therefore, you can't do this. You need to push those people to cancel their visa. Is there any change in annual leave per new labour law? No, there isn't. It's still 30 calendar days. For those of you that are on working days, and I think most of us have moved over to that, so that's 22 working days. Is it possible to share the PowerPoint? Of course, just let Kaza know that you want to do that. Could you please clarify the leave encashment calculation at the time of employee's final settlement? Is it on basic or gross salary? Gross salary. It's never been on basic. I know a lot of employers do it. Good for you if you get away with it, but it's always been on total salary. Please share the recording. I'll let Casey do that. Is there any change in overtime hours? No, I would have mentioned it. It's just declaring the fact that it's basic pay. And whereas previously it talked about Friday, working on a Friday, of course, now it's on the official day of rest. Please explain the severance calculation. Hopefully I have. Can you clarify more on the annual leave during probationary period? Okay, let me just clarify that a little more. Under today's labour law, they may be accruing leave from the date of joining, but they don't get paid leave during their probationary period. This means currently, once they've worked 6 months, they already have 50% of their leave entitlement accrued. Going forward, this just means that they can take it, and if they do take it, it's paid. And if they do leave in their probationary period, you owe them the pro rata amount of annual leave. It's paid to them. Who will be responsible to pay the cost of status change? Who will pay? Well, I'm guessing you, not the employee, because you can't deduct this from the employee's fee, which is why I suspect we will see a change in this coming in the future where it'll be on renewal. Do you have any update on the later contracts template? No. And I doubt at the moment, today on the 20th of January, that even the ministries have this. So I think that's what they're scrabbling to work. Are other leaves applicable during probationary period? The sickness, no. And compassionate leave, yes, it doesn't say you can't pay it. The only statement that it says under leaves is that you don't get paid sick pay during your probationary period. I do have a sample of an employee handbook. I'll leave you to come to me. Should we process gratuity for part-time staff? If an employee is on your employment visa, they are entitled to gratuity. So if you employ them on a spouse visa, if you employ them on your company visa, they're entitled to gratuity. Kazi, can you just mute everyone again?
Yeah.
Now, the issue we have here is what happens if they're on somebody else's visa and they're now working part-time for you? That's the outstanding question we don't have. The other outstanding question is, if someone's full-time with you, then goes part-time, is the gratuity paid on the part-time salary at the end or on an average of the hours that they've worked? And if they go part-time and then go full-time, then they leave, does that mean I now have to pay gratuity on their full-time salary? Or again, is there a pro rata amount? And I think logic steps in here to say it'll be on a pro rata of the hours that they've worked. But again, that's not clear and that should be explained in the future. Right, we're down to 4 minutes. Regarding the overtime calculation, will the calculation of working days and weekend be the same now? Yes, but on basic pay only. If you just renewed your contract and wanted to leave after 1 month, is the new employee will pay for the cost of visa? No, you can no longer deduct the cost of visa from employees. FYI, you never could, but we got away with it for a few years here. Is there any chance of maximum security? It used to be 24 months of basic pay. Yes, that's still there. That's not changed. The sick leave during probationary is unpaid. Shall it be reduced from the service period? It's still sick leave is unpaid during notice period. Presentation. Everybody seems wants a copy of the presentation. When a new baby is sick, a mother can take an additional 30 days paid or fully. It's on the slide, and I can't 100% remember. I believe it's full pay and then an additional 30 days unpaid. It's on the slide. It's also in labour law. What's the penalty of breaking the limited contract? No, that's still not there because I think the limit, as I said, the limited contract penalties that are stated in old labour law are removed from new labour law. Now, all you need to do for those people that are now on limited and you're going to move them to the new limited contract, you just need to make sure you give them contractual notice of 3 months, 90 days, and that will cover you, because I know with the people on limited contracts, they're there for a reason. You don't want to lose them. Just make sure you put them on 3 months notice. For the nursing break, how is it going to be for female employees currently on maternity? Well, if they are partway through their 18 months, now's the time to reduce it to 6 months. And now's the time to say, actually, the new law says it's 6 months, not 18. We need to have a chat now. I'm going to give you, and I would give them a little bit of notice to say that this is now changing and this is no longer allowed. How is the calculation of 144 hours in overtime in 3 weeks work? It's exactly the overtime. The only difference in overtime is the fact it's confirming that it's on basic pay. The new visa will be like SOE companies, which is 3. The new visa will be a 3-year valid visa like they have on free zones. Since paternity leave can be taken over a period of 6 months, can the employee take it in parts? That's down to you, your agreement with the employee. That's your choice. Doesn't mention that it has to be, and I thought it was in 3 months that you had to take it. As mentioned in the company leave policy presentation, there's some points still not clear. Is it possible waiting for an update, please? Mention the company leave policy handbooks on boarding presentation for. I'm not sure I understand that question. I'm sorry. I have a different version of labour law directions. Can you share authenticated version with all new changes? Yes, if you ask Kazi, we'll send it to you. Right, it's now 11. Kazi, we can carry on for a couple more minutes if that's all right with you.
Yeah. We can definitely carry on, and formally, some people, if they want to, they have some meetings to join, they can join. But we will carry some more time to answer the questions, to clarify, and then we. Okay, let's continue.
Okay. There's another good question here, and I think where it says, I think you mean advanced holiday. Does annual leave need to be fully paid, as earlier laws stated, basic and housing, if any? So companies paid only basic and housing without transportation. Okay, that was only on advanced holiday. That wasn't on holiday on date of leaving. Okay. The question about advanced holiday, I don't remember seeing it in labour law stated anymore, so I'm not sure we need to give it. I've always been on the side of the employee here to say, well, why would it be any less? You're paying me full holiday when I'm actually not in the room. What if I'm asking for the money to be in advance? I should have the full amount. But I know some employers only advance housing and basic because labour law says. But if people are leaving employment, it's on total holiday, total salary, not just basic, not just housing. If the employee wants to terminate the limited contract, then what are the costs involved in this? Remember, the new limited contract is exactly the same as the unlimited contract, okay, today. So it's got contractual notice in it. As long as you could give them the contractual notice, it's exactly the same. What would the process be for hiring someone on a golden visa? Well, we all love to know the answer to that. We'd all firstly like to have a golden visa. That's where your PRO needs to go and advise on that one. Visa currently expires in 2 years. How does a contract stand valid for 3 years? Because the new, for those that are new in country, previously the mainland visa used to be for 3 years. It changed, I don't know, 7, 8 years back, and it's now going back to 3 years. So when you get a visa stamp, it will now be for 3 years rather than 2. Article 3 says renewal can be equal or shorter term. Can you email me that one direct, because I'd have to have labour law in front of me. Is the renewal of a contract can be less for 3 years? It can be less than 3 years. So if you only want them for 1 year, then make sure you limit it to 1 year. Unlimited to limited, will it mean fresh starting employment? No. The date of leaving holds. The settlement holds the same date of leaving. So it's exactly the same. So even though we're changing contract, you're not terminating someone, you're just issuing a different type of contract. After 6 months of joining, can the employee eligible to take annual leave? They are eligible to take annual leave from day 1 of employment if you allow them to have that renewed. Andrew, please email me direct. I can't in the timeline go direct.
Questions or some questions related to specifically to your company, then you can email it and we can see.
Okay. Can the employer put the terminated staff on garden leave? I've always made sure that when your offer letter it says paid notice or in lieu of notice, so then it's clear that they can go on garden leave. I've put employees on garden leave. So it doesn't mention it. I think that's new phrasing here, but I do it as long as you've got it written down in their offer letter, terms and conditions of employment, and in your handbook. Will need to be changed to before. Yes, and Anush, you're asking about it needs to be changed by the 2nd of February 2023. It does need to be renewed by the 2nd of February 2023. I'm suggesting you hold fire so that we know what the changes and process involved in that, and more importantly, the costs. Would the employer be responsible for providing the employees with insurance even if they're under a golden visa? I think you mean medical insurance. And I've always made sure that the company medical insurance policies say company sponsored employees are included in the company medical insurance, because the sponsor needs to pay for the medical insurance. So if someone's on their parental visa or their husband's visa, they should be providing them with the medical insurance. You're not meant to. Under probation required to render notice period. B, it was explained on the probationary period, they have to give you 14 days or 30 days, depending on where they're going. If they're leaving the country, they have to give you 14 days. If they're going to a new employer, 30 days, and you now need to give them 14 days. What would the payment of gratuity be for part-time employees? It will be based on their basic pay. So their basic pay should be prorated from their full-time salary. Yes, an employee working in a showroom can work more than 8, but cannot work more than 9. And a paid break is an unpaid break. So their contractual hours are for 10 in a day if you've got them on 9. And I'll just take the last question here as the last question. Can we still have 22 working days as annual leave rather than 30 calendar days? Yes, because it's your interpretation. 22 working days is 30 calendar days. With labour law is the basic. You cannot go below labour law. You can make labour law better. You cannot make it worse. 22 working days is the same as 30 calendar days on a 5-day-a-week contract. Right, I think that's all the questions. Everybody wants a copy, I think, of the presentation.
Yeah, most of the questions, people want a copy of the presentation, the recording, the UAE labor law copy. So we will send it to you across. And thank you, Claire. So now finally you have a break for water, right? It's great. Thank you so much. I'm pleased to see a lovely attendance. I think this topic needs some more sessions, so we'll try to discuss what more we can do. And if we are getting some more updates, so we'll try to arrange some more sessions. Thanks to all of you. If there is something really bothering you in terms of implementing it, do send us an email and we will try to help you out for that as well. Thank you, Claire. Thank you all the participants, and thanks for joining.
Thank you.
Thank you so much.
Thank you, Claire. Thank you, Kashi. We have officer.
It was very helpful.
This was
Please share some FAQs.
better than paid sessions. Thank you very much.
Thank you.
Thank you.
Yeah, if you can share FAQs, that will be very helpful.
Thank you so much.
This is a
Yeah,
good
on the
idea.
FAQs, we will compile them and we will share them as well. But just give us a week to do that, yeah.
Thank you so
Sure.
much.
Thank you.
Thank you, Claire.
Thank you. Bye-bye.
We need more sessions like that.
We will try to arrange more sessions on this, and we'll try to cover some if there are any more updates coming up. Yeah, definitely.
Yes, thank you for my accept. Thank you.
Thank you. Thank you.
Thank you, Claire. Thank you, Kazi. Thank you.
Thank you, Kazi.
You're welcome.
Thank you. Welcome.
Thank you.
Welcome. Thank you. Welcome, Danilo.
Thank you, Claire and Kazi. Have a nice day.
Thank you, Shweta. Farooqan, thank you.
Thank you, Kashi, and thank you, Claire. Have a lovely day.
Welcome.
Thank you, Claire and
Very
Kazi.
informative.
Thank you so much. Really,
Thank you so
really
much.
helpful.
Welcome. Thank you so much. Ending.
Excellent and well done.
Thank you so much. Thank you for the appreciation. Thank you.
Thank you so much.
Thank you. Thank you. Bye.
I hope after the session you will be forwarding that details.
Yes, yes. After the session, give us some time and we will send you the details. Yeah.
So you have our email IDs?
Yeah, yeah. You registered with your email ID. So we have the email IDs from which you registered. All the participants who registered, we have their IDs.
I think there's still quite a few people that are working. So can you just sign out of the session, please, guys? Thank you.
Yeah, I'm just waiting, Claire, that people sign out.
Yeah, I think they went straight back to work and signed out. How many attended?
336 was the last number which I saw.
Attending?
Attending 336. It was a
Actually
very
online?
online attending. Yeah, it's a very good number. Very good response from people. We still have some 30-40 people here.
Hi, Kaysar. This is Binoy.
Yeah, hi, Binoy.
Hi. See, basically what I did is I have posted the link in other groups as well. So I was active on, there were around 10 to 15 groups were there in HR. So I have forwarded and there were more than 200 to 300 participants, which has, yeah. So it was a great section as well.
Thank you, Benoy. Send me your number in WhatsApp.
I have already sent you a connection link in your email address.
Okay.
Sorry, not in your email, in your LinkedIn.
Okay.
Yeah.
I will note it down. I will note it
Yeah.
down. Thank you, Benoit.
Even Miss Clara, in case if we can also accept my LinkedIn connection, that would be great.
We will do.
No
Definitely.
problem.
Thank you. Thank you.
Benoit.
Yes. I'm leaving. Thank you. Have a nice day. See you. Bye.
Thank you.
Cheers.
I will end up the meeting now. Okay. Thank you.
Yeah.